today, then we'll be on the record discussing this. I assume the court reporter is ready to go. She can just give me the thumbs up. Great. We will proceed with the first docketed matter. This particular matter has multiple pending actions associated with it. I will go ahead and read the docketed item title, and then we will ask the division to proceed after we take appearance of counsel. Right now, I'll read the docketed item. It's docketed number 2019-014, cause number C/007/0045. Request by the Utah Division of Oil, Gas, and Mining to forfeit the reclamation surety in order to complete reclamation of the Wellington Dry Coal Cleaning Facility. At this time, I believe we would like to take appearances of counsel with the division.
Thank you. This is Haley Souza with the division.
And the first matter is the request by the division to, excuse me, let me get to my notes here to make sure I'm saying the right things. But that, I'm sorry, I've lost my notes. Anyway, you're presenting a motion to strike the submittal by Ironshore.
Yes, that is correct. The rules of civil procedure require that respondents file memorandum in opposition within 14 a motion, and so this particular filing was filed 205 days late. So the division respectfully requests that it be stricken from the record.
Is there a representative, an attorney for Ironshore that would like to make an appearance in this matter at this time?
Yes, thank you, Mr. Chairman. My name is Josh Sundloff on behalf of Ironshore. And I'm not sure now is the time, but we'd like to make a response to the division's motion to strike.
What we would probably do, it seems like the right way to do this, is to allow the division to address their motion to strike, and then we would normally, I guess, we would not allow you to give a presentation because you're a defaulted party, but we are going to allow you the opportunity to be heard after the division makes their presentation. So what we would like to do, I think, is to go ahead with the division first, hear their case, and then we will hear from you representing Ironshore.
Thank you.
So, Ms. Souza, please proceed.
So, Chairman Hansen, I would just like to clarify the motion to strike is not being discussed at this moment. I am to proceed with my presentation. Is that correct?
Yeah, we're dealing.
System check, system check. Network confirmation check. Going to YouTube. We appreciate everyone's patience. We have YouTube by to testing caption to we have our network. We have issues. We're going to give this another measure stable. Found out why. Testing 1, 2, check, check. Testing 1, 2, check, check. Restoring link to YouTube minus audio. Testing 1, 2, check, check. Testing 1, 2. Stand by. System check, system check. We believe we have rectified what disrupted the meeting. Stand by to return to the proceeding. Mr. Chairman, I think we've resolved the technical issues. If you'd like to go back on the record.
Great. Thank you, Paul. Sounds like we've resolved the issues. Thank you. And apologize to the public and to the persons who are attending this hearing for the delay. But these things happen out of our control. So where we left off was we were asking Ms. Sousa to discuss her motion to strike. So if we're ready, Michelle, court reporter, if you can give me your thumbs up, we'll assume that we're back on the record. Great. Thank you. Ms. Sousa.
Thank you, Vice Chair Hansen. As I said before, the Utah Rules of Civil Procedure require that respondents have 14 days following the filing of a motion to file any responsive memorandum in opposition. So if Ironshore wished to file a memorandum in opposition, they would have needed to do that no later than December 24th, 2019. Ironshore's memo is 205 days late, and therefore Ironshore has waived its opportunity to oppose the division's motion. The memo should be stricken from the record.
Okay, thank you. Mr. Sutherland from Ironshore, if you'd like to discuss or present your case as to why you should be allowed to talk or speak on this matter, we could hear that. We don't necessarily think it's appropriate to hear your pleading that you submitted, but tell us why you should be able to make your pleading.
Sure. And I appreciate you giving that latitude. So I guess it sounds like there's a question as to whether Ironshore will be able to either keep its opposition, its written brief in the record, or present argument orally here. I guess I'll address both combined. The gist of Ironshore's request or position as to why the written brief should not be stricken is, Ironshore does not necessarily deny that it was filed at this late date. All Ironshore is asking, Ironshore also recognizes that it is a defaulted party. All Ironshore is asking is that the board grant some latitude. There's really no prejudice to the division by this filing being here, and all it will serve to do is to inform the board more fully as it deliberates or makes its decision. And I think there's a little bit of precedent in this matter that would allow this, not only because there's been recent written filings and other filings made by the division in the last few days, let alone weeks. But the board, for example, issued an order on April 30th of 2020. And, that board did not necessarily address Ironshore's ability to provide any briefing or oral argument, but it illustrated, I think, a principle that could apply here. And that is the board gave the division 6 days within which it could provide supplemental non-cumulative briefing. And so the fact that Ironshore has provided its opposition brief now 7 days before this hearing, I think would follow with that same principle and latitude that the board allowed the division back in its April 30th order. And so Ironshore is simply asking that the board keep its written brief in the record and allow Ironshore, despite its defaulted party status, an opportunity to provide argument here. And really, we're just seeking some latitude or discretion from the board. So that's Ironshore's position.
Okay. Ms. Souza, would you like to respond, please?
Yes, I would. Thank you. One point that Mr. Sunloff said was that the division was not prejudiced by his filing being in the record. And I would just like to dispute that fact, because Mr. Sunloff's briefing does provide additional legal arguments that Ironshore failed to bring at the original hearing because they were a defaulting party. And it is the division's belief that those new legal arguments that are only now being raised are in fact prejudicial to the division.
Okay, thank you. I think at this point the board should deliberate on this matter to make a determination as how best to go forward. So, with apologies, we're going to ask the board members to go back into our other website so that we can deliberate in private and discuss this matter. So we'll go off the record while we deliberate, and we'll come back as soon as we get this matter discussed.
time.
Thank you. Michelle, are you, can you hear me and ready to go? Great, thank you. We will go back on the record. The board members have discussed the division's motion to strike, and I believe a motion by the board is in order.
I move that we accept the division's order to strike.
Is there a second?
Second.
Discussion on the motion, if any. Seeing none, we'll take a roll call vote on the motion. Julianne, could you call the roll?
I apologize.
Mr. Rich Gordon, how do you vote?
I vote yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Steve Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chair Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chair, I have 7 affirmative votes.
Thank you, Julianne. The motion carries. At this point, I think it's appropriate that the division proceed with their presentation on the docketed item. Ms. Sousa, I assume you're making the presentation. Uh-oh. Think Ms. Sousa is frozen in time.
I was muted. I'm sorry.
Great. This is always an adventure, isn't it?
It is. Do you guys see my screen?
Yes.
Okay. If I go like this, does it make it bigger? Did I lose you guys?
Nope, that worked great. Thank you.
Okay. Okay. All right. So, board members, first off, I'd just like to thank you guys very much for giving the division an additional opportunity to have oral arguments on this. I know that considerable time has passed since this was originally heard and since the original motion for reconsideration was filed by the division. And so I just want to thank you guys for giving us this opportunity. So motions for rehearing are need to, so they're governed by Utah Admin Code 641-100-200, and that requires that any petitions for rehearing specifically set forth why the previous order was unlawful, unreasonable, or unfair. So the division in this instance asserts that there are 3 reasons why the board's order was unlawful, unreasonable, and unfair, and that is because all coal processing waste must be deposited within the permitted area, all violations of the Coal Act and the coal rules must be abated, and the surety must be used to ensure compliance with the Coal Act and the coal rules. The board's order allows for this violation to be to remain unabated. It allows the waste to be deposited off-site, and it doesn't allow the division to ensure compliance with the Coal Act and the coal rules through the use of the surety. So I'd like to give the board just a little bit of background on SMACRA and on primacy. So SMACRA, when it was originally passed, was envisioned that it would be a joint venture between the federal government and the states, wherein the states, if they wish to, they could adopt their own sets of rules that would be no less stringent than the SMACRA rules, and then the state would be allowed to have primacy over the coal regulatory structure. So what that means essentially is that they would be allowed to be the regulator over the coal industry. So Utah did choose to seek primacy, and so they passed the Coal Act and corresponding coal rules, and primacy was granted to Utah in, I think it was 1981. So Utah has been the regulator over coal in the state of Utah since that time. However, Utah is still subject to oversight by the Office of Surface Mining. So if the state of Utah fails to address violations that it knows has occurred, OSM has the opportunity to issue what's called a 10-day notice to the state of Utah, which requires the state of Utah to take some action to ensure that that violation has been abated. So in this specific instance, we have a violation that Utah knows exists, and we are at risk of receiving a 10-day notice from OSM that would essentially direct us to make sure that this violation is abated. And if Utah fails to abate that violation, or to ensure that that violation is abated, Utah could potentially lose its primacy over coal regulation. So with that brief history, I will get into the bulk of this presentation. So the first argument that the division states is that all waste must be deposited within the permit area. This is clearly established in the coal rules. There are numerous locations throughout the coal rules where it specifically discusses that waste be deposited within the permit area specifically, or it may allude to the fact that waste must be placed on the permitted area by requiring that the area be suitable for reclamation and post-mining land use. In addition to the coal rules, the Coal Act specifically notes that all waste must be deposited within the permit area. That particular statute states that operators are required to protect offsite areas from slides or damage and not deposit waste accumulations outside the permit area. This is a novel issue for this board, so there is no controlling law within the state of Utah that deals with this specific situation. So the only thing we can do is look outside of the state of Utah and see what other jurisdictions have done. In Wyoming, the District Court for Wyoming noted in Northwest Pipeline GP v. Chevron. In that case, Chevron had been mining on their land, but the mining on their land had caused damage off the permit area. And in that instance, the District Court stated that Chevron had the statutory and regulatory duty to protect offsite areas from damage occurring from Chevron's surface coal mining and reclamation operations. So the regulations, the statute, and case law is clear that an operator has an affirmative duty to protect offsite areas and to ensure that coal processing waste is deposited on the permitted area. However, the operator here failed to do so, and so the division must be allowed to return the waste to the permitted area. The second reason that the division believes the board's order was unlawful, unreasonable, or unfair is because all violations must be abated according to the Coal Act and the coal rules. So the coal rules set up this system of escalation for enforcement actions. So in the first instance, when a violation is discovered, the division must issue a notice of violation, and within that, the division must provide a specific period of time for abatement to occur. And unless that abatement occurs, the notice of violation cannot be terminated. If the time for abatement ends and the abatement hasn't taken place and the violation still exists, then the division is required to escalate that notice of violation to a cessation order. And in that same instance, the cessation order can only be terminated upon abatement of the violation. The Interior Board of Surface Mining and Appeals dealt with a case called Carbon Fuel Company, and it was a case where a coal company, there had been mud, coal, and stones that were deposited outside of the permit area. And when the inspector visiting the site noticed this, he issued a cessation order and required that that material that had been deposited offsite be immediately returned to the permitted area. The operator appealed, and the Interior Board of Surface Mining Appeals affirmed the cessation order. And it noted that it is clear that the Act contemplates that the consequences of a violation of its requirements may extend off the permit area. And importantly, the Interior Board of Surface Mining Appeals also specifically declined to hold that the permit boundary, as identified in a state permit, protects a permittee in all cases from being required to abate the detrimental consequences of its operations. So this clearly demonstrates that despite the fact that there is this permit boundary, when operators deposit materials outside those permit boundaries, they are required to return that material back to within the permit. The final reason that the division believes the board's order was unlawful, unreasonable, or unfair is because the surety must be used to ensure compliance. The legislative intent with SMACRA was very clear on this specific issue. It recognized that there would be times when there would be offsite impacts, and the surety should be allowed to be used to cure those offsite impacts. It recognized there is a difficulty in determining the appropriate surety amount because operations necessarily have to be designed such that consequences of this nature would be prevented just in order to qualify for a permit. So the intent recognizes that this is a rare situation, that it's difficult to plan for. But if you continue reading in the legislative intent, it states that these things do happen. Unplanned consequences occasionally do occur. And when they do occur, if those consequences are identified prior to the release of the surety, that the surety should be withheld and not released unless and until the damage that was that occurred outside the permit area is abated. Additionally, the coal rules specifically note that surety funds are to be used to abate violations where the operator is refusing or is unable to abate the violation, or if the operator defaults on the conditions under which the bond was accepted, then the division is required to take action to forfeit the bond and use those bond funds to reclaim the unabated violation. In another case, King Coal Company, this case was out of Pennsylvania. The Pennsylvania court there, so in King Coal, what happened was the operator had done work on site that had caused off-site violations. So they had done improper diversions, which led to silting off-site. and they had mined off the permit area also. And in that case, the court had specifically noted that the environmental damage off-site is the legal equivalent of a direct violation of the bond conditions. So when looking at this language from the coal rules that specifically state that if the operator defaults on the conditions under which the bond was accepted, in this case, causing damage off-site, then the division must take action to forfeit the bond and to use that bond to abate the violation. The division respectfully requests that the board enter an order modifying its November 13th, 2019 order to allow the division to use the forfeited surety funds to return the coal processing waste to the permit area. And board members, I am open to any questions that you might have.
Thank you, Ms. Sousa. Board members, I think this is the appropriate time to ask questions. And if you would raise your hand, I see Mr. Borden would like to ask a question. Go ahead.
Thank you. Haley, a quick question. You cited several examples where there was harm occurring outside the permit boundaries. Is this material causing harm? In particular, does it pose a geochemical or an ecological exposure risk of some kind?
So to my knowledge, the material has not been tested. However, it is coal processing waste, which means that it, by nature, must be within the permit area because the rules in the statute contemplate that if it's outside the permit area, then it's necessarily causing harm, regardless of whether or not the chemical nature of it is such that it's acidic or may cause other issues. The statute and the rules require that it be put onto the permitted area because it's necessarily causing harm just by nature of being outside the permitted area.
So does that mean that the existing rules do not allow beneficial reuse of benign mining waste outside a permit boundary, which can actually be an environmental benefit if the material is geochemically benign and is put to valid beneficial use?
There are, it's my understanding that is possible, but in those situations, the material being used offsite is not coal processing waste. It's some other material that has been designated as something different. In this specific case, we are dealing with coal processing waste. And so in this specific case, we would not be able to use these specific materials offsite for a beneficial use elsewhere.
And I assume that may have been a shorthand because many coal processing wastes are geochemically reactive, but not necessarily all. All right, thank you.
Thank you. Mr. Brown.
So to summarize what Ms. Sousa said, coal processing waste is not a beneficiation waste. Is that correct?
That is my understanding of the Coal Act and the coal rules, yes.
Okay. Thank you for presenting legal arguments. I believe this is the first time the board has actually seen any legal arguments that may justify the use of bond funds. However, I have a couple of questions. A couple of cases you presented talk about bond releases, but it does not talk about bond funds being used for reclamation. It says a bond will be, I think it was two cases before this slide where you said until the material was moved back to the site that the bond couldn't be released. That makes sense because they essentially hold the permittee hostage to get the stuff back where it belongs, but it does not specifically authorize the use for bonds to clean the material up if they don't do that. Or am I misunderstanding what that case actually says.
Well, so in that situation, the case didn't go so far as to requiring the forfeiture of the bond. So in that case, the operator did return the waste to the permitted area on their own. So it was not necessary that the regulatory agency in that case take the next step, which would have required forfeiture of the bond and would have required that the bond funds be used to then to move that material back to the permitted site.
That may be a bit of a reach to conclude that, and it's intuitive based on some of the other things that you presented. I thought that the Chevron case that you presented was compelling, but again, point out that was resolved in a civil court of law, not in front of a board. It was done through the civil court system. But again, I do appreciate these arguments. These were not presented when we inquired originally, and I think my concern and the concern of other board members that there may be some precedent being set that would put bond companies and permittees at risk on how far their bond could be used to reclaim material from third party or other parties using their materials. So I appreciate that information.
Do you mind if I follow up really quickly on that point?
Please do.
It's important to note that the liability isn't going to extend forever. So this is a specific violation. The permittee in this specific case violated the Coal Act and the coal rules, and they knew that they were doing that because they had been informed of that fact by the division and they had been told not to remove it. So if this material had been something different from coal processing waste, something perhaps a beneficial material like board member Borden was pointing to, then there wouldn't be any need to use reclamation funds to retrieve that material and bring it back to the permit site, because that would be perfectly acceptable for them to sell that material. What they've done in this specific case is that they've deposited something specific that is a violation. And so it's just the violation that's being abated. It's not any commercial transaction that might occur of other materials. It's just for the abatement of this specific violation.
So Ms. Souza, I think we understand that as a board. The board has no issue and does not challenge the fact that requirements of the bond or the mine permit or the site permit were violated. We agree with that. We also agree that this waste material has to be returned to its site. We realize that that is a violation. That is not an issue with this board, as far as I am aware. What was at issue with us, and what still may be a question for us to deliberate on, is this the appropriate use of bond funds? Because we were not presented with any compelling legal arguments when we first heard this. You have done that today. I realize you weren't on shift at that time. I appreciate the work that has been done to help me understand this, at least. And I just want to make it clear that the board does understand the predicament that this puts the division in. And it is not our intent to have the board lose its primacy or to allow a material to be left at a site out of compliance. Our intent is to make sure that the application of bond funds is appropriate, because those of us that have dealt with bonds before recognize how difficult it is to obtain surety and how at risk the surety industry is. And so we have to be very careful with this, and that was why I was quite adamant and cross-examined this on first hearing. And with that, Mr. Chair, I'll yield back. Thank you.
Thank you, Mike. Mr. Brown. Mr. Church, you have a comment.
I was wondering, Ms. Souza, if you could tell me what the process is for the division to accept the terms of a bond. is that bond reviewed to see if there's any conflicts between what the contractual arrangement is between the bonding company is compared to what kind of regulations, as the division understands, it needs to cover?
Sure.
And has the bond ever been rejected as not being sufficient?
I will have to defer to Dana regarding the question of whether a bond has ever been rejected. But what I can speak to is that in a bonding situation, the operator is required to submit a reclamation agreement to the division that both the operator and the division are a party to. However, one piece of that reclamation agreement is an agreement between the division and the surety, where the surety agrees to the to understanding what the requirements of the Utah regulatory system is. And in that surety, or in that agreement with the surety company, I can tell you some specific language that is on point for this issue. So in the document that the surety company signed, they acknowledge that the surety's bond will remain in effect until the permittee's reclamation obligations have been met and released by the division, and is conditioned upon the faithful performance of all the requirements of the Act, the applicable rules and regulations, and the approved permit. So the surety recognizes that they will continue to be held liable. The surety signed this document. They will continue to be held liable so long as they're until the faithful performance of all the requirements has been discharged. So in this situation, the operator has not completed faithful performance of all of the requirements. And so the surety necessarily cannot be released from that obligation. And they've signed this agreement stating that they understand as such. Additionally, the same agreement states that the surety agrees to indemnify the division from all expenses which may be sustained as a result of the permittee's failure to comply with the conditions of the reclamation obligation. So again, in this situation, there's this reclamation obligation that hasn't been abated, and the surety has specifically agreed in this contract that they have signed that they will indemnify the division for any expenses that result from that, from the permittee's failure to conduct that reclamation. And there's one other term here. This states that the terms for release of the bond are agreed. So it states that essentially that the bond can't be released until the reclamation agreement has been completed. And so the permittee has failed to complete reclamation. And so the surety has specifically agreed that they recognize their responsibility to ensure that that reclamation takes place.
Thank you, Haley.
It looks
Dana,
like Dana's on to answer your other question.
Yeah, so
Dana, have bonds been rejected before by surety companies?
yes, the surety company has the, they review these bonds. They don't need to renew them. The only catch there is that they have to give the division 90 days notice. And in the meantime, if the company cannot find a replacement bond, the old bonding company is on the hook. And so we would call a bond at that point. Also, any surety bond, the company, we've rejected surety bonds before because our rules require an A- or better rating through AM Best in order for a surety company to be able to give a bond in the state of Utah. So those requirements were met. That reclamation contract that Haley spoke of was signed and understood by all parties. And they know when they sign that they're obligating themselves to whatever the mine does. And like I said, they can cancel bonds, but if the company can't come up with a replacement bond somehow, then they're still required to follow through on the surety.
Thank you, Dana. I yield back, Mr. Chair.
Thank you, Mr. Church. Ms. Davis.
Dana, I'm glad you're on the line because my question is related to Rich Borden's question. So the issue is coal processing waste was used to pave a road. Is that a beneficial use? What is the environmental harm of using that coal processing waste on that road? And what's the environmental harm of moving it again?
There's no environmental harm in moving it again. We're looking at this as it's an offsite impact. It's not a road. It's not a parking lot. It's an offsite impact. And I will repeat, when this violation was first written, I was in a meeting in Washington, D.C. with the director of the Office of Surface Mining, the Assistant Secretary for Lands and Minerals, and all of the regional directors for OSM. And I asked in that meeting, is there any way, if this material is found to be inert, that it could be used for a beneficial use and that we can say that this is not an offsite impact? And every single person in that room said no, that the way it's very clear in SMACRA, if something comes out of a coal mine, it's either sent to a power plant to be burned, or nowadays, I guess they're sent to carbon fiber facilities, or it's waste, and there's no in between, and waste must be properly disposed of in a refuse pile that is designed and engineered under the coal rules. So it doesn't, the SMACRA does not care whether it's an inert material or not. But I will say removing this material and putting it back where it goes will not cause any environmental harm. It will not be a problem whatsoever.
Any further? Thank you, Ms. Davis. I do have a few questions. Sorry, Mr. Brown.
Just maybe for Susan's benefit and for mine or other board members, typically beneficiation wastes are defined by law and wastes are defined by law. And so the term beneficiation waste, at least in my side of the mining industry, was very specific on what materials could be used and were designated as beneficiation wastes. If it was not a beneficiation waste, then it was designated a waste material. It has to be handled differently at great expense and sometimes irrespective of the content of the material. It's simply a designation. And so my question earlier to Haley was, is this a beneficiation waste? And it is clearly not. In fact, I'm not a SMACRA expert, but it sounds like that this material is specifically designated as a waste material under the regulations. Is that correct?
Yes, that's correct. It is very specifically a waste material, and then there are very specific pages of rules on how you need to properly bury that and cover it with inert material.
Thank you.
Mr. Borton.
Yeah, I appreciate that this is if you will, it's a designated waste and it can't be put to an offsite reuse. But I think that's in the legal world. In the real world, it sounds like it probably is not causing any harm because it's in a parking lot as a road base. If that gets pulled out, is the owner of the parking lot going to have to import road base from somewhere else? In that case, yes, the carbon footprint and some other measures, we would be doing a small amount of additional environmental impact to take it out to comply with the law. Is that a fair assessment of the situation?
I think that's fair. I think everyone's correct, but I think Mike earlier said that he didn't want the board's decision to hamper the board in the future in any way. And the division is looking at this as, we don't want this to hamper us in the future in any way. This is an offsite impact. We're trying to fix an offsite impact. We don't want a decision to carry forward and then say the offsite impact is contaminating a stream. And then what if we can't fix that because we said that this wasn't a big enough deal? So that's where the board or the division is coming from, is we don't want a precedent set that says that offsite impacts aren't important. They are. That's our whole program, is to minimize disturbance within the permit area and to prevent offsite impacts. So that's it's still an offsite impact. It might not be a large impact. We're not killing fish. It's not going into people's drinking water, but it's still an offsite impact under the coal rules, and it needs to be cured just as any other violation would be.
All right. Thank you. We don't need to discuss it further, I think, but it would be a much simpler open and shut case if there was an true environmental harm that could be demonstrated. Huh. Thank you.
Mr. Brown.
Sorry to belabor this. Waste designation is extremely important in the mining industry. And I fully understand the issue about inertness and true environmental harm. I was going to ask that question myself. The conundrum for the division is what Haley described earlier as it relates to their primacy. So if the division were to make a determination that this material was a beneficial use, the feds could probably overfile and take away your primacy and still do the same thing that you're trying to do to protect your primacy. Is that not correct?
Yes, that's correct. And they could go even further and write a violation to a federal violation and still use the surety to fix the offsite impact. So we understand that the board wants to think about this and make a fair decision, but that's a very good point, Mr. Brown. Our primacy could be at stake, and even beyond that, the feds could just write their own violation and they're co-named on the bond, and they can just take the bond and do what they want with it. So as the division, we would rather handle things ourselves and show that we can do things the right way and not get crosswise with OSM. Not that we're scared of them, but we want to be able to implement our program in Utah the way that we're supposed to. And I think that that's all we're asking, is to be able to follow the rules as we see that they're written and try to do what we're asked of and keep our primacy and keep Utah as one of the best regulated states in the country.
Thank you, Dana. Mr. Chair, I yield back.
Thank you. I do have several questions. First, either Dana or Ms. Souza can address, has the OSM threatened the TDN on this matter?
No. We have quarterly meetings with them. They're monitoring the situation. They're aware of this request for relief that we have before the board today. They haven't threatened anything, but it would just have to play out. They wouldn't be able to do anything until a decision was final, and then they would probably, or they could take action. But no, at this time, they're not threatening anything.
Okay, thank you. Another question I have is, did not ATCO and Bowie Refined Coal enter into an agreement, a purchase agreement, that ATCO was buying this material and placing it on their parking lot? In other words, Bowie Refined Coal was not under cover of darkness or serendipitously moving this material off-site. they had a commercial agreement with ATCO to provide them with this material to place in their coal truck hauling parking lot. Is that not correct?
That is correct. And the division would have no way of knowing about this commercial agreement outside of the anonymous tip that we received. So it's true that they were not doing this under cover of darkness, but they certainly weren't making it known to the division either.
Of the cases that were cited, Northwest Pipeline versus Chevron, was there any commercial agreement between the two parties about the advancement of the high wall towards the pipeline corridor? Or was this just something where Chevron advanced their high wall and it weakened the pipeline bedding outside their permit area? In other words, this was not a commercial agreement between Chevron and Northwest on this whole pipeline issue. It was just an impact outside the immediate adjacent permit area, correct?
My understanding of that case was that there were previous agreements in place that allowed the pipeline to have an easement, and that Chevron was not allowed to take any action that would harm that easement. So there was some type of contractual agreement in that prior case as well.
On the other cases, were there, I think the carbon fuel case, that sounds like there was some material that was dropping off of some of the coal trucks or the haul trucks and contaminating a road. And so that was not really a commercial agreement between two parties, as I understand it.
That is correct.
And then Dana, this is a question for you. Was any of the waste material at Bowie Refined Coal, or for that matter, any other waste rock site material hauled off to, say, the cogen plant in East Carbon?
Other sites have taken material to the Sunnyside Cogen plant. When this first started looking like we were going to have to reclaim, we asked both the cogen plant and the facility across the street,
Savage.
Savage, yeah, thank you. The Savage facility, if they would be interested in any of this material, and we were clearly told no. No, this is not, it's not spec'd enough to run through the cogen plant. The cogen plant has a short life right now, and they have plenty of material coming out of the old Sunnyside mine and the Star Point refuse, and also they've taken some from the Wellington prep plant. They don't need this material. It would not be beneficial, or it wouldn't be efficient cost-wise to them. But I don't want to be antagonistic, but you're questioning about the commercial, that they got paid to take this material off-site. In my mind, that's worse. They're getting paid. They were profiting from breaking the rules, not only from getting paid to take that material off-site, but also avoiding having to dispose of it themselves in the proper manner that the rules require. But that's just my opinion. I know that this is a different case from a lot of things that we're looking at. Just trying to be factual.
Sure, I appreciate that. Would you say that ATCO has no experience in the coal mining rules?
I wouldn't say they have no experience, but I can't say what they knew, what ATCO knew, and I can't personally say what Wellington knew. But we had a witness, and if we need a witness going forward, that the witness was there at the previous meeting, and we didn't get to that part to testify. But an employee of Wellington Dry Coal was, he made it clear that they knew what they were doing. But again,
Okay,
if you want to hear from him, you'll have to hear from him. That's just hearsay on my part.
sure. I guess the point I was making earlier about the cogen plan was the discussion regarding coal waste, and once it's placed in a waste rock site and
yeah.
it's been determined to be waste material, we can reclassify that as a fuel material.
Yes, but also the Sunnyside Cogen has a SMACRA permit. So anything that they're taking on their site, if for some reason it's not burnable or that something's wrong with it, they have a refuse pile on site where they can properly bury this according to the rules. And so, yeah, I didn't mean to say that all coal waste was unusable, but it still can either go get burned somewhere or used for a beneficial use, such as being turned into carbon fibers, but it can't be used as a road base or backfilling open pit mines. It can be placed underground if needed, but it's very precisely controlled under SMACRA. And again, I asked everyone that's in charge of OSM, is there anywhere in the country where this is allowed? It seems to me like if it could pass some tests geochemically that maybe we could do this. And the answer was no, that's not possible. And that is not what's intended. And we just can't do that.
Okay, thank you. I think one last question. In the previous, and this probably is to Haley, Ms. Souza, in the board's original decision document, it was discussed that there are civil avenues or civil courts, the avenue available to the division to pursue abating this violation. In other words, the matter could have been handled civilly to obtain the funds to reclaim the parking lot. Is that not true? Or am I misreading that?
It's partially true, I would say. So it is true that there are civil avenues that the division can and should pursue, and I have an update on those following this presentation as well. But those civil penalties should not be what's used to abate the violation. So the scheme of the regulatory structure is that the surety is used to abate violations, and penalties can be assessed by the division, but those are not tied to abating a specific violation. So yes, there are civil avenues that the division maybe should have taken back when this violation was first being discovered. There are civil avenues that the division should probably take at this point. But those civil avenues are for the purpose of essentially acting as a deterrent for bad operators to deter them from violating, and not as a remedy for abating violations. That specific piece is within the purview of the surety.
Well, I'm just reading from the original hearing, and one of the issues that was brought up by, I think, Mr. Alder, was that the board should assess a civil penalty for failure of BRCW to address this violation and cessation order as appropriate to compensate the state for cost of abatement and to penalize the operator for its willful and continuing violation of the Coal Act. As I'm reading that, it sounds like the division was asking the board to allow for assessment of civil penalties to cover the cost of the abatement.
Those two pieces of the notice of agency action were bifurcated, so those weren't actually heard at that prior hearing. But I think there's a slight distinction in what Mr. Alder was actually asking and what I think perhaps your inference might be, and you can please correct me if I'm wrong, but if the division ends up needing to go out and do this reclamation and they need to find their own funds to do it, that's the taxpayer who's doing it. And perhaps the division may be able to assess penalties, and those penalties can then be used to kind of pay the taxpayer back. In this specific situation, this operator is in the wind. So they have mines, several other mines all over the country that the surety is currently doing reclamation for because they are non-responsive and people. I suspect that it may be difficult for us to actually be awarded civil penalties, to actually collect on the civil penalties. I'm sorry. That doesn't mean that we shouldn't try. We should certainly make every effort to get civil penalties such that it acts as a deterrent like it's supposed to. But ultimately, those penalties are not intended to pay for the abatement itself. They're intended to deter the operator from behaving badly.
I understand. I guess my point was not that we should rely on it necessarily, but that there are different avenues that are available to the division other than just relying on the reclamation bond to abate this violation. Would that not be correct?
Yeah, I think that's a fair point, yes.
Okay. Well, thank you. I know those were maybe pointed questions, and I didn't mean to be aggressive about them. I was just trying to get some information.
Sure.
Board members, are there any other questions or comments you'd like to make at this time? Seeing none, I think at this point we would probably want to deliberate, deliberate on this matter. Also, since it is noon, a little after, is there a desire to deliberate, come back and issue our findings or make a statement and then go to lunch? Or do you want to deliberate and go to lunch and then come back and make a statement?
Deliberate and just get this over.
Okay. Anybody else have a concern with that we'll deliberate, come back, make a statement or make a ruling, whichever, and then go to lunch?
Mr.
Sounds like
Chair,
that's what we're going to do. Yes, Mr. Brown.
could we get Miss Souza to simply summarize what it is we're supposed to be deliberating and deciding on once again, please, just so we're all clear?
Yes, I would love to, and I will put this up so that you can see it. I'm sorry I lost my connection and so it fell off. This is specific to what the board is requesting that you deliberate on. So the division is requesting that the board enter an order modifying its November 13, 2019 order to allow the division to use forfeited surety funds to return the coal processing waste to the permit area. And I will leave this up so that you guys can see it if you'd like.
Thank you.
Thank you.
Well, at this time, we will go off the record and go into deliberations. So that means, once again, we'll have to link into the other website so we can have this discussion. Thank you all. We'll be back as quick as we can.
Mr. Chairman, I believe we've resolved the mute function issue. Michelle, our court reporter, if you're able to hear us, would you please give us a hand indication?
Great. Okay. Thank you. We'll go back on the record and to discuss how to move forward on this docketed item. And this is a complex issue, and we've had very informative presentations, and we've had some very in-depth discussions on how to proceed. And unfortunately, or fortunately, I think we would like to take this matter under advisement, and we will be addressing some of those issues that are before us that we really need to come to a conclusion with. And we'll take this under advisement, and hopefully we can get a resolution within the next few weeks. Would that be appropriate, Mike? So that's where we stand on this issue. I don't think we need to make a motion or have a vote. We'll just take it under advisement. And I apologize to those folks who were waiting in line, but we're going to take a break for lunch, and we'll come back at 1:40. So we'll go back off the record.
2, 1. Testing 1, 2. Michael or Mike, could you give me a sound check real quick on Google Meet?
Hey, Paul. I can hear you loud and clear. How do I sound?
You sound good. Thank you. It's been a strange technology day. Okay.
Well, thanks for all the hard work.
Thank you. Michelle, if you could give us a confirmation.
She gave us a thumbs up. Did you see that, Paul?
Michelle, if you could give us that thumbs up one more time.
I'm ready.
Okay, thank you.
If we're back on the record, I'm not hearing anything. I still don't hear anything.
Michelle, we're back on the record, but we haven't started yet.
Oh. Sorry, I saw his lips moving.
Okay, I'm really embarrassed now because I didn't have my phone, my microphone on. That was practice. I'll do this again. The next item on the agenda is docket number 2020-005, cause number 379-01, in the matter of the request for agency action of High Point Operating Corporation. This matter is continued to the August hearing. The next item is docket number 2020-011, cause number 475-02, in the matter of the request for agency action of Middle Fork Energy Uinta LLC. In this matter, it was heard before a hearing examiner on July 8th. And at this point, I would think that we would hear from the division and their representative on this matter. Who from the division is giving their presentation? Mr. Rogers?
Yeah, this is John Rogers.
Great, proceed if you would.
Okay, thank you, Chairman Hanson. Good afternoon, Chairman Hanson and members of the board. My name is John Rogers with the Division of Oil, Gas, and Mining. I was appointed by this board to act as a hearing examiner in docket number 2020-011, cause number 475-02, in the matter of the request for agency action of Middle Fork Energy, Uinta LLC, for an order suspending Utah Administrative Code Rules R 649-3-2, R 649-3-10, and R 649-3-11, paragraphs 1 and 2, as to the KJ2 federal unit comprised of portions of Township 6 and 7 South, ranges 21 through 23 East, Salt Lake Meridian, Uinta County, Utah. This action came before me as a hearing examiner on July 8, 2020 at 9 a.m. This matter was prevented virtually, just like we are today, because of the COVID-19 pandemic and self-isolation requirements. Bailey Sosa, Assistant Attorney General, appeared as attorney for the division. Fred McDonald represented Middle Fork, and Middle Fork had 2 witnesses testify remotely. My counsel was Gordon Rowe with the Attorney General's office. Middle Fork is the current operator of the KJ2 federal unit. The unit was approved by the BLM effective October 13, 2017. The oil and gas underlining the unit area is primarily owned by the United States, 86.85%, with the remainder owned by Sitla, 13.15%. The Walker Hollow unit covers portions of the same lands, but is limited to depth shallower than the KJ2 unit. And the Midnight unit, which also covers portions of the same land, terminated in 2007. There are no other unit overlaps or conflicts within the KJ2 unit. The following have relevant leasehold operating rights in the unit: Middle Fork, Robert L. Bayless, Producer LLC, Kerr McGee Oil and Gas Onshore LP, Stripper Operators Inc., Finley Production Company LP, CH4 Energy Finley, Utah LLC. Within the unit, all tracts are committed except Unit Tract 4. There are currently no board orders pertaining to the unit area, and consequently, the general operational rules have managed a unit. This includes Utah Administrative Codes as previously mentioned. R 649.3.2, location and siting of vertical and statewide spacing for horizontal wells. R 649.3-10, tolerances for vertical drilling. R 649.3-11, paragraphs 1 and 2, directional drilling. All these rules have been applicable in the unit area. However, well location and density patterns within the unit area has additionally been determined in accordance with unit agreements, and in particular, the annual plans of unit development with the BLM. Middle Fork and its predecessors were able to drill 4 wells within the unit area within the confines of these general operational rules and approved annual plans of unit development and permits from the BLM and from the Division of Oil, Gas, and Mining. However, further development in the unit by Middle Fork will focus beneath the base of the Wasatch Formation and the Mesa Verde Group and Upper Manco Shale. Middle Fork plans to drill additional wells in the unit area from multi-well paths utilizing an S-curve wells to reach bottom hole locations due to topographical constraints, to maximize utility of infrastructure and minimizing surface and environmental impacts. However, such development will require directional drilling, which will traverse lease and unit tract boundaries and consequently numerous exception locations. This will require the vacating of the previously mentioned rules. Microseismic analysis reflects a fracture orientation of approximately north 69 degrees west, with fracture half lengths of approximately 450 feet with a width of approximately 200 feet. Consequently, optimal well density in the area is 20-acre spacing with well space 330 feet north-south, which should result in drainage occurring no more than 460 feet and justifying a conforming setback. I had questioned this setback in order to ensure the protection of correlative rights of owners within the lands adjacent to the unit area. Middle Forks agreed that any future well within the unit area will be located no closer than 460 feet to the unit boundary or an uncommented unit tract boundary within the unit. Middle Fork has further agreed that should it be established that the drainage is extending beyond the 460-foot setback referenced above, it will report to the board and with a plan to protect correlative rights and production interests owners of the adjacent lands being drained, if necessary, in a modification of this order. The BLM and SITLA have certified the operations under the terms of the governing unit agreement are in the public interest for the purpose and more properly conserving natural resource. Given the findings outlined above, suspending the requested rules as to the lands within the unit area is fair, reasonable, and justified, provided, However, that no future well may be drilled closer than 460 feet from the boundary of the unit area or an uncommitted tract therein without administrative approval of the division or board in order to protect correlative rights, and the requirement of the unit operator to provide a directional survey for any directionally drilled well remains applicable. The suspension should apply to any expansion of the unit and should terminate to any lands contracted out of the unit. This action is consistent with several previous board orders granting similar relief under similar circumstances. After the presentation of the evidence and testimony submitted, is my finding that Middle Fork has demonstrated good cause and has sustained its burden of proof for granting the request as presented. Vacating the rules will not impede the conservation of oil and gas or cause waste. In my opinion, the request satisfies all statutory and regulatory requirements for the release fund. I, as a hearing officer, recommend that the order be accepted as written. I at this time would entertain any questions if you have.
Members of the board, do you have any questions? Seeing none, I see that Mr. McDonald is here, I assume to represent Middle Fork Energy. Would you like to make a comment or statement?
Yes, Mr. Chairman, I appreciate Mr. Rogers' time and effort in hearing examiner. I agree with his findings. Counsel for the division and myself and for the hearing examiner have agreed upon the form of the order, which Mr. Rogers has signed and should be before the board. And we ask that you enter that today if possible. Can you hear me okay?
Mike Brown could hear you, Fred.
Okay.
I heard you.
Okay, I'm sorry, I had myself turned off again. Yes, I heard you. I was just asking if the board had any questions that they would like to ask Mr. McDonald. And seeing none, I was just handed the document from board counsel and he has approved it, and I will review it quickly and sign it today.
Thank you, Mr. Chairman.
I guess at this point, the board needs to make a motion to accept. Yeah, sorry about that.
Mr. Chairman, I'll make the motion to accept the
Is there a
proposal
second?
from the hearing.
I'll second that.
Thank you. Julianne, could you call the roll call vote?
Yes, Mr. Chair. Mr. Richard Borden, how do you vote? Yay or nay?
Yay.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Sorry, yes.
Mr. Chris Hansen, Chairman Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Thank you, Mr. Chair. I have 7 affirmative votes.
Thank you, Ms. Carter. Now I will sign the document. And I appreciate your patience on this. That concludes this docketed item. We'll move on to the next. Docket number 2020-012, cause number 196-51. In the matter of notice of agency action by the Division of Oil, Gas, and Mining seeking an order, 1, forfeiting the reclamation bond provided by North Star Gas Company, Inc. of Texas for the state 2-7 gas well, and 2, authorizing the division to use the amount forfeited to plug and reclaim the wells secured by the reclamation bond. At this time, I believe we will take appearances of counsel. Is there anybody here other than Ms. Haley Sousa for this matter? Seeing only Ms. Sousa, can you provide us with an update?
Yes, before we begin, I did file a motion for an entry of order of default, and so I'd ask the board to make a ruling on that motion now. And I can go through the relevant facts if you guys need to hear about the service and describe how service was proper in this instance.
I apologize for that delay. Just, Ms. Souza, has there been any communications or any submittals from North Star on this matter?
No, there have not.
So up until now, there has been nothing.
Absolutely, that is correct.
In that case, it seems like we should just go ahead and have a motion presented to accept the division's pleading on this matter. If there's a motion and a second, we can put on it.
So moved.
Is there a second?
Second.
Thank you. Any discussion? Seeing or hearing none, let's go for the vote. Ms. Carter, could you take a roll call vote for this?
Mr. Richard Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote? Mr. Moon?
Yes.
Thank you. Mr. Chairman, I have 7 affirmative votes.
Great. Thank you.
So, if I may,
Please.
before, I'm sorry, Chairman Hanson. Before I begin, before I begin my presentation, I just wanted to give the board an update on these default orders. So, in this presentation is going to look different from past presentations that have been given to the board in default situations. So the Utah Administrative Procedures Act requires that in all default proceedings that the board must still, quote, conduct any further proceedings necessary to complete the proceedings without the participation of the party in default and determine all issues in the proceeding, including those affecting the defaulting party, end quote. So in the past, the division has interpreted this to mean a full presentation was still required, and so they swore in witnesses and they examined their witnesses. But a closer reading of these rules and applicable case law suggests that such an onerous process is not required. Rather, it's sufficient for divisions counsel to summarize the relevant facts for the board so that the board can make a determination on the legal facts. So I will now commence that presentation. All right, are you guys seeing that?
Yeah.
Yes, it's showing up.
Excellent. So so in this case, there are 3 wells. There's the state 27 well, the state 3614 well, and the state 3616 well. These wells are owned and operated by North Star Gas Company, Inc. of Texas. They are all 3 located in Grand County, and they are roughly 20 miles northwest of the town of Westwater, Utah. They were all three spud in 1980 and have changed ownership several times, but as stated, now they are owned and operated by North Star Gas Company. So in this notice of agency action, we have two causes of action. The first is requesting forfeiture on the basis that the operator is refusing or is unable to conduct plugging and site restoration. So each of these three wells has a history of notices of violation, but most recently, beginning in 2018, the division began issuing notices of violation for failure to file production reports, failure to notify the division of shut-in status, and failure to keep North Star's business registration active in Utah. They've let that expire. And these NOVs required that North Star either provide full cost bonding for the well or submit necessary information to demonstrate integrity of the wells, or to plug and abandon, or to place them into production. North Star has failed to respond to any of these NOVs. Additionally, these wells sit on Sitla minerals, and so Sitla also in 2018 issued notices of violation for each of the wells, noting that they had not received any royalty payments since January of 2016. And again, North Star ignored those notices of violation, and so Sitla terminated the leases for two of the three wells. One of the wells, the lease was not terminated because there's an adjacent well that's operated by a different operator that is producing. So that lease still exists, but two of the three wells had their leases terminated by Sitla. And so with regards to this first cause of action, the fact that North Star has failed to respond to the division's NOVs, has failed to take any action on the NOVs to either produce from the wells or to plug and abandon, and their willingness to equally disregard Sitla's notices of violation, together with their failure to remain current with the Utah Division of Corporations and Commercial Code, demonstrates that the operator refuses or is unable to conduct plugging and site restoration. The second cause of action states that requests the board to forfeit the bond because bonds shall be forfeited when an operator is in non-compliance as to the conditions of a permit issued by the division. So in this case, the operator, well, let me back up. So as a condition of any permit, there's the requirement that the operator remain in compliance with all of the rules and regulations. So in essence, if an operator is in violation of one of the rules, then they are in violation of their permit because that is a condition of the permit. So in this instance, North Star is in violation of several of the rules. They have failed to notify the division of the well's shut-in status, and failed to maintain continuous operation of the subject wells, and failed to plug and abandon the subject wells after 5 years of non-activity or non-productivity in violation of the shut-in well rule. They have failed to file monthly production reports in violation of the production reporting rule. They have, so on let me switch this slide. Two of the wells are in violation of the identification rule. This picture was taken at the state 3614 well, but as you can see in the picture, it's misidentified as the state 3616 rule, or I'm sorry, well. This identification rule requires that each well show the name and number of the well at the site. So this is a violation of the identification rule. Additionally, at the 3616 well, The same rule, the identification rule, requires that the this signage be posted prominently. And as you can see here, it's propped up on the ground. That is improper and a violation of the identification rule. Additionally, this is at the State 27 well, this picture. So at the State 27 well, there's a 300 barrel tank that's on site, and it contains roughly plus or minus 275 barrels of fluids. This is in violation of the pollution and surface damage control rule, and that rule requires that the operator not allow for the accumulation of oil or other materials that create a fire hazard. And it also requires good housekeeping practices. And so this collection of oil and allowing it to remain on site is in violation of the pollution and surface damage control rule. And also at the 3614 site, there is this tank that is buried partially underground. The capacity is unknown because there's no documentation on the tank showing how big it is, and because it's buried, it's impossible for the inspector to fully gauge how large it is. But that tank is full of fluids, roughly down 5 or 6 feet down. So at the State 3614 well, they're also in violation of this pollution and surface damage control rule because they're allowing the accumulation of oil and other materials that create a fire hazard, and it's in contravention of good housekeeping practices. And the relief that the division is requesting in this case is to order North Star's interest in the $90,000 collateral bond that's currently held by BBVA USA to be forfeited and released to the division, to authorize the division to use the forfeited funds to complete the plugging and restoration of the subject wells as permitted by Utah Admin Code 649-3-1.16, to authorize the division to take any additional action as necessary to recover any funds required for complete plugging and restoration that may be in excess of the forfeited funds, and to grant any further relief that the board deems just and proper. And so before I finish up, I would like to motion that the exhibits previously filed be included in the record.
So admitted. I was going to ask if there are any questions from the board members, but yeah, so admitted. Yeah, now that we've admitted it, I'm glad I've got Mike on my right shoulder because this could be a comedy if it wasn't for him. Board members, do you have any questions about this matter of Ms. Souza? Mr. Borden?
Yes. Does the division feel that the funds available via the bond are sufficient to completely plug and reclaim these 3 well sites?
No, I don't believe that they do. I don't have a number though from division staff on exactly how much more it will require. But it's my understanding that 90,000 will not be enough for these 3 wells.
Thank you.
Any other questions from the board? Seeing none, then a motion is probably...
I have a question, Mr. Chair, sorry.
Okay. Go ahead, Mr. Brown.
Ms. Souza, point number 4, grant further relief that the board deems just and proper. What kinds of examples might we deem just and proper? We've just been instructed previously that if we were to tell you to go ahead and seek civil penalties or something, you couldn't use that funding. Teach us a little bit about what number 4 means.
Well, I think that that's first off, that's an excellent question. Second off, I don't have a very good answer for you, but I can say that back in, and this predated me, but looking at past hearings back in March, I think you guys heard the Hinto matter. And in that case, the board took a look at the facts, and I think they were able to take the ruling a little bit farther and note that this was waste, something that the division hadn't previously requested a ruling on. And the division was able, or I'm sorry, the board was able to include other items in that order to make it more broad. And I would consider those things to be things that the board deems just and proper. But to be honest, it's routine legalese that we lawyers like to put in our filings to cover our butts. And let's just be honest about that. Just in case you guys think of something else that might be great.
Thank you for your honesty. That was just and proper. I yield back, Mr. Chair.
Thank you, Mr. Brown. I believe Mr. Begley has a comment.
Thank you, Mr. Chairman. Mike Begley, counsel for the board. Mr. Brown, typically if you have an appearing party, that some additional action and further action to stop perhaps environmental degradation that's not before the board and the pleadings that are articulated by the division, the board could grant any other further additional relief to try to cure the situation at hand, but that's typically for an appearing party. But even if there wasn't an appearing party, if the board would want to address something that's not specifically addressed in the request for agency action, notice of agency action, that's when it just allows the board a little bit more powers that they can go beyond what the release requested by the division.
Thank you, Mike.
Thank you, Mr. Begley. Well, I believe at this time, if there's no further discussion, we're at the point where a motion could be made to grant the relief requested. We don't need to list all 4 items. We can just refer to the relief requested by the division. Whoever wants to make that motion.
I would move that we approve the request for agency action.
I'll second.
It's been moved and seconded. Any discussion on the motion? Okay, seeing none. Ms. Carter, could you take a roll call vote on this?
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Thank you. Mr. Chairman, I have 7 affirmative votes.
Thank you, Ms. Carter. Is there anything else we need to do on this? Yes. Okay, thank you. Ms. Haley, would the division prepare the order on this matter?
Yes, I will. Thank you.
All right. Thank you. I thought maybe I was on mute again.
It was me this time.
Thank you. We'll move on to the next docketed agenda item. Docket number 2020-013, cause number 191-08, in the matter of the request for agency action of Running Foxes Petroleum Corporation. I believe this matter has been continued, and that it's going to be scheduled to be heard by a hearing examiner on August 11th, 2020. I'm sorry. Oh, okay. Is that your understanding, division?
Yes, it is.
Okay, thank you. And it will be continued. next item on our agenda, docket number 2020-015, cause number 076-02. In the matter of the notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order, 1, forfeiting the reclamation bond provided by Patmos Energy LLC for the CBM-1 well. 2, authorizing the division to use the amount forfeited to plug and reclaim the well. And 3, authorize the division to take any additional action as necessary to recover associated costs to the extent the amounts forfeited are insufficient. I believe at this time we would take appearances by council for a status update. Ms. Haley, would you like to go first?
But I believe that Mr. Mayo would like to provide an update on this one.
Oh, I'm sorry. I did not see him on my screen.
I just popped in, Chairman. Can everyone hear me? Okay. Mitch Mayo of Lear & Lear PLLC on behalf of Patmos Energy in this case. Yesterday, Haley and I spent a significant amount of time talking about this case. I was able to finally get an update from my client, and I'd like to share that with you. At the last hearing, at the 11th hour, my client retained me, Patmos retained me to move for a continuance from the June docket to the July docket. The reasoning for that was accepted by the board was that Patmos Energy is a wholly owned entity owned by an individual named Charles K. Breland Jr. He is currently in bankruptcy, and the well is an asset to be administered through the bankruptcy court in Alabama. My client, the bankruptcy trustee on behalf of Patmos, retained me on June 10th, and we made a motion to continue based on certain expectations that we would move the bankruptcy court for approval to employ Gray Rock as a contractor to shut in and plug and abandon the well. And that the board essentially give the bankruptcy court the time it needs to do that so that Patmos can employ the contractor and save money. Patmos filed, or the bankruptcy trustee, I should say, filed a application to employ in late June. And on July 14th, that matter was heard by the bankruptcy court in Alabama. The bankruptcy court granted that application to employ. However, as is the case with this board, the oral ruling comes and then it takes a little bit of time for the finalized written order to come. When I spoke to counsel yesterday, he anticipated that the judge would enter the order. He said typically within about 5 business days of filing. That written order was filed roughly the 16th, is my best estimation. Counsel was out of the office and couldn't verify the exact filing date. And so counsel, bankruptcy trustee anticipates that the bankruptcy court will issue its formal written order granting the application to imply Gray Rock sometime by the end of the week. Bankruptcy counsel confirmed that it would be contacting Gray Rock immediately upon issuance of that order, and also confirmed yesterday that Gray Rock is able to begin work within 5 to 7 business days of being notified. And so in sum, Patmos is here essentially making an oral motion for continuance, I believe with the division stipulation. But if that's a step too far, at least without their opposition, to allow Patmos the additional 2 to 3 weeks that it needs to kind of administer this plugging and abandoning of the well in a way that maximizes the assets for the estate distribution.
Okay, thank you. Ms. Sousa, you have any discussion or response to that request?
The division is in support.
I assume at this point, then we would have to receive a motion for continuance and consider it at that time. I don't know that there's anything more we need to do on this matter other than to say thank you for the update, and we will address the continuance request when it's before us officially.
Is it possible for me to orally move for that continuance now? I know under the rules it's allowed. Otherwise the subject matter of the notice of agency action would probably need to be heard today and would result in, essentially an order plugging in the well 2 or 3 days before the client was able to plug it itself.
My counsel on my right-hand side is nodding his head yes. We could do that. As long as there's no objection from the division.
There's none.
So the way to proceed is just to have the board. Okay. At this time, the board will entertain a motion to continue this matter.
So moved, Mr. Chairman.
Thank you, Mr. Brown.
Seconded.
Seconded by Ms. Davis. Thank you. Any discussion on the motion? Seeing none. Ms. Carter, could you go ahead and have the roll count vote?
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chair Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you, Ms. Carter. Since it is an oral vote, okay, all I have to do is pronounce that the motion to continue is passed, and it'll be continued. I love this authority. I mean,
Thank you, Chairman. I appreciate it.
The next docketed item is docket number 2020-017, cause number S-057-0010. Notice of agency action by the Utah Division of Oil, Gas, and Mining seeking an order 1, withdrawing the notice of intent to commence small mining operations for Pine Ridge Excavation and Landscapes. 2, forfeiting the reclamation bond provided for the Pine Ridge Mine. Excuse me. 3, authorizing the division to use the amount forfeited to reclaim the surface of the Pine Ridge Mine. And 4, requesting the Attorney General recover assessed penalties. There was some discussion that this be continued. Could I ask the division where we are on this?
Yes, Mr. Chairman, Gordon Rowe for the division on this matter. And yesterday, I filed a motion to continue this matter. I've been in discussions with the operator as recently as yesterday about resolving this without board action. We like to see if he could get something done in the next month, and if we don't see substantial progress, we plan on moving forward with this action, likely with an amended notice of agency action and supplemental exhibits. So we would just request that the board continue this matter for 1 month so we can try to resolve it.
Okay, thank you. Good luck with that. I hope that works. But just for a show of hands to make this a little bit easier and quicker, because we don't need to take a roll call vote, is there a show of hands among the board members to go ahead and continue this matter? Affirmatively. Looks like we're all in agreement to continue this matter. I assume until the August hearing?
Correct.
Okay, then it's continued to the August hearing. At this point, can we take a 5-minute break, go off the record and just take a 5-minute break and return just shortly after 2:30? If that's all right, thank you.
1.
Thank you. We'll go back on the record, and I'm not on mute, so we should be okay. Michelle, can you hear me? Great. We're on a roll. The next item on our agenda is docket number 2020-018, cause number 606-01. In the matter of notice of agency action by the Division of Oil, Gas, and Mining seeking an order 1, forfeiting the reclamation bond provided by Tiger Energy Operating, LLC for the faucet 1-26A1E oil well, and 2, authorizing the division to use the amount forfeited to plug and reclaim the wells secured by the reclamation bond. At this time, we'll take appearances of counsel, and I'm assuming at this point that it is just Mr. Lyons. I don't see any other folks being represented here, so Mr. Lyons, please proceed. And by the way, Mr. Lyons is new and will be kind to you in your first presentation.
Thank you. I do know that they asked that Haley would introduce me beforehand.
Okay,
so
great.
I will pass it to her just a second.
That would be very much appreciated.
Well, Chair Hansen, you did such a great job. I don't know that much more remains to be said, but I will just let everybody know that Mr. Lyons is our new O'Hara. So when we eventually lose Gordon, Charles is the person that's coming up into that role. And so we will have Charles for the next 2 years. You will see him more frequently at these hearings, and hopefully you'll get to know him. I also wanted to note that because of COVID restrictions, the Utah Supreme Court did issue an order for temporary amendments to bar admissions procedures during the COVID-19 outbreak. And what that order did is it allows Mr. Lyons to forego the onerous requirement of taking the bar exam in lieu of practicing under other attorneys. So Charles is currently going through that process. He's learning and growing as much as possible, and he is required, in order to practice before you today, he was required to receive written permission both from a supervising attorney and from the client. So I have granted Mr. Lyons permission to practice underneath me to present at this hearing, and the division has also given Mr. Lyons authorization to do that. So I just wanted to let everybody know in advance, Charles is not currently licensed to practice law in the state of Utah, but he is practicing under my direction. And so if you do feel like being terribly mean to somebody, please direct your anger to me as opposed to Mr. Lyons. And from there, Mr. Lyons, you can go ahead.
Okay, thanks, Haley. Appreciate that. And thanks to Chairman Hansen and the board and everybody. I'm excited to be here and to present today. So I'm be presenting docket number 2020-018, cause number 606-01. And the division filed this notice of agency action with the board on June 10th of 2020. This is an agency action against involving Tiger Energy Operating LLC, which I'll refer to as just Tiger, and 3 subject wells, the faucet 1-26A1E, the Josie 1A-3B5, and the V Miles 1 well. Service was effectuated and proper. Because the respondents failed to file a written response with the board or indicate that they would participate in today's hearing, the division filed a motion for entry of default order with the board on July 20th of 2020. So at this time, the division would like to make that motion that the board enter an order of default for this matter.
At this point, I think the board would consider the motion of default. I assume we have to have a roll call vote again. Yes. Is there a board member that would like to make the motion to
So moved.
proceed with this? A second?
I'll second that.
Any discussion on the motion to move forward? Seeing and hearing none. Ms. Carter, could you call the roll call vote?
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote? Mr. Brown?
Sorry, muted. Yes.
Thank you. Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Thank you. Mr. Chair, I have 7 affirmative votes.
Thank you. The motion is passed. And at this point, please proceed, Mr. Lyons.
Okay, thank you. So as Haley mentioned earlier in an earlier docketed matter, the division is doing a more streamlined process for these default hearings. And so that's what I'll be presenting to you today. First, I'd like to go through some of the facts that led up to this NOAA. Essentially, Tiger became the operator of these wells, and they've had a history of non-compliance previously, even before their time, that continued up until filing this notice of agency action. So the current disposition of these wells, the Fawcett well was plugged between 2015, 2017 and requires surface work. The V-Miles 1 well is the same. It was plugged between 2015, 2017 and requires surface work, while the Josie well is unplugged and remains out of production. So in this slide presentation, this is just showing operatorship that Tiger is operating these wells, and these were filed with as Exhibit D with the divisions. And so this is just a map of the location of the Fawcett well, the Josie well, and the V-Miles 1 well. And these were all entered as Exhibit A into the board's filing. So just like I mentioned, I'm going to go through some of the background of violations. So this dates back to 2013. The division issued, this is before Tiger became operator even, the division issued an NOV to, at the time, owner Homeland Gas and Oil that was applicable to all 3 subject wells, to which the division filed a notice of agency action against Homeland. But at that time, Homeland presented evidence that Homeland and Tiger had an agreement that Tiger would take over some of Homeland's wells, which then led to a stipulated order with the division and both those parties that included a production and plugging schedule, where the division required either Tiger or Homeland to begin rework operations to either place in production or plug at least one of then 12 wells which were subject to that, which included the 3 subject wells of this notice of agency action. Tiger and Homeland both failed to comply with that production and plugging schedule of that 2013 stipulated order, which led to another division order and a modification to that 2013 stipulated order. Due to a continued non-compliance with that 2013 stipulated order, the division issued Tiger another division order in 2015 requiring Tiger, and at this point, Homeland was out of the picture, and this is just Tiger operating these wells at this time. So the division issued Tiger the division order requiring Tiger to immediately plug the subject wells, post an additional $60,000 bond for each of the subject wells, and provide an estimate for plugging and site restoration. A year later, Tiger, this is 2016, Tiger filed a notice of intent to plug and abandon the V-Miles 1 well and filed a notice of intent to plug the faucet well, which was approved by the division. These things still have not occurred to this day, but at that time, the division issued another notice of violation for a violation that had occurred at the V-Miles 1 well that involved an oil spill from a heater treater, which migrated off-site to a nearby field. That matter was satisfactorily closed later, about 2 weeks after that incident occurred in 2017. So Tiger filed another NOI to reclaim the faucet well site in November of 2017 and to reclaim the V-Miles 1 well site, which were both approved by the division. However, again, that did not actually take place. And on May 3rd, 2018, the Tiger and the division entered into a stipulation and agreement involving the subject wells. All of these that I've mentioned were filed as exhibits with the division, with the board, with the division's exhibit filing. But the 2018 stipulation agreement is Exhibit P, and I think has language in there that is really pertinent to today's action. The 2018 stipulation stated that Tiger had completed plugging the V-Miles 1 and faucet wells. However, Tiger had not completed surface work as required. The 2018 stipulation also stated that Tiger would put the Josie well into production and complete the remaining surface work on the V-Miles 1 and faucet wells by May 30th of 2018. The terms and conditions of that 2018 stipulation stated that if Tiger failed to bring the Josie well into production or in the alternative plug and complete the surface work in accordance with division rules, as well as the remaining surface work on the V-Miles 1 well and faucet wells, Tiger consented to the entry of an order pursuant to Rule 649-3-1.16, forfeiting the bonds to the division and authorizing the division to take other actions as required to recover the costs of completing the plugging and reclamation. Additionally, the division will file a notice of agency action before the board seeking all appropriate remedies, including forfeiting Tiger's reclamation bond to proceed with completing surface reclamation and plugging the unplugged wells. A year later, after that stipulation was entered into, the division and Tiger had another meeting where Tiger stated that it would commence plugging of the Josie well by the end of August 2019, would determine the status of the faucet well and report back to the division with a plan by June 17th of 2019, and submit the subsequent P&A sundries for the V-Miles 1 well by June 21st of 2019. As of today, none of these actions committed to by Tiger took place, and Tiger has never complied with the 2018 stipulation. So as I mentioned earlier, the current disposition of these wells, the faucet well still requires surface work. The V-Miles 1 well requires surface work. The Josie well remains unplugged and out of production. Respondents did not reply or choose to participate in this hearing. However, the only response that we got was from one of the surface owners, Tyler Murray, who is the surface owner of the property for the faucet well, indicated that there are some concrete pads that he would like to stay on site because he is intending to build a corral there. So if all the surface work would be done, they would prefer to leave that there. But he also did indicate that when he took ownership of that property, he had sought a loan to help build that corral, and he was denied because there was some outstanding paperwork that we didn't really have the details of, but he was unable to get the loan to do the corral because of these issues with involved with plugging that well. So it's creating issues for the surface owners as well. So that's the facts leading up to this. And so the division is requesting 3 actions of the board. To forfeit the blanket bond provided to the division and held by RLI Insurance Company, provided to guarantee the plugging and restoration of the subject wells. 2, to authorize the division to use the forfeited funds to plug the subject wells and reclaim the associated surface impacts from the subject wells. and authorize the division to take any and all additional actions necessary to recover the costs of plugging and reclaiming the subject wells to the extent the amounts forfeited are insufficient. And this is just an exhibit B showing the bond that Tiger has. So the division is bringing 3 causes of actions. First is refusal or inability of the operator to conduct necessary reclamation. 2, noncompliance with permit conditions issued by the division. And 3, authorization to recover all costs of plugging and restoration in the event of insufficient bonding. So for the first cause of action, the rules require the division to take action to have the board forfeit an operator's bond where the operator refuses or is unable to conduct plugging and site restoration. After proper notice and opportunity for a hearing, the board may order the division to collect the forfeited bond and use the forfeited funds to plug and restore the wells to which the bond applies, or to contract for the plugging and restoration work with the surety, the operator, or another party capable of performing the necessary work. This slide is just showing, and I've already mentioned this, this is just the 2018 stipulation entered in as Exhibit P, saying that Tiger consented to basically what we're asking now and filing this notice of agency action. So Tiger, as I said today, still to this day, this is all outstanding. So Tiger's demonstrated its refusal or inability to conduct plugging and site restoration of the subject wells as evidenced by failure to follow through with stated commitments to do so on multiple occasions and for failing to comply with the terms and conditions of the 2018 stipulation. Since Tiger has refused or is unable to plug and reclaim the subject wells, the board should forfeit the collateral bond and allow the division to use the funds to plug the subject wells and reclaim the well sites. The second cause of action that the division is bringing is the rules require the division to take action to have the board forfeit an operator's bond where the operator is in non-compliance as to the conditions of a permit issued by the division. I just went over this middle bullet point on the last one, so in interest of time, I'll skip over that. But the division's permit conditions require well locations and well operations to be in compliance with all rules and orders of the board. These are just instances of violations that have occurred. Division orders H, or are exhibits H and J. As I stated in the factual analysis going up to this, that there's been multiple instances of division orders, notices of violation. They've all been filed as the division's exhibits to this matter, and they're all in violation of permits at each time and still remain to this day. So Tiger is in non-compliance with division's permit conditions because they've failed to plug and reclaim the Josie well and has failed to complete surface reclamation for the faucet and V-Miles 1 wells in accordance with 649-3-34. Therefore, the board should forfeit the collateral bond and allow the division to use the funds to plug subject wells and reclaim the well sites. And finally, third cause of action, in the event the amount forfeited is insufficient to pay for the full cost of the plugging and restoration, the division may complete or authorize completion of plugging and restoration and may recover from the operator all costs of plugging and restoration in excess of the amount forfeited. So the board should authorize the division to take additional action as necessary to recover any funds from Tiger required for to complete plugging and restoration that may be in excess of those forfeited funds. So in the end, the relief requested today is that the board enter an order as follows. 1, order Tiger's interest in the surety bond totaling $120,000 held by RLI Insurance Company be forfeited and released to the division. 2, to authorize the division to use the forfeited funds to complete the plugging and restoration of the subject wells as permitted. Authorize the division to take additional action as necessary to recover any funds required to complete plugging and restoration that may be in excess of the forfeited funds, and grant further relief that the board deems just and proper. And that concludes my presentation. And I would just ask that the exhibits, I've moved to enter the exhibits into the record.
Okay, thank you. Let me make sure that I've got the exhibits as offered. And make sure I've got the right document here. Exhibit A, when we start. Exhibits A, B, C, D, E, F, G, H. I, J, K, L, M, N, O, P, Q, R, S, and T.
That's correct.
I almost recited the alphabet. And as soon as I get done here, I will say that.
Mr. Chairman, we can't hear you.
I apologize. I will not go through that again. I was on mute. Maybe next time they'll just give me a microphone without the button. Exhibits A through T have been offered as evidence and they are so admitted. Is there any questions or discussion from the board members? And
Mr.
thank you, Mr. Brown.
I have a
reminding me.
question.
Yes, Lavon, please proceed.
And this is for Charles. Of the other wells listed on that stipulation, the other, I don't know, 6 or 7 wells, has all the work required been done?
I don't know if the work that was required been done beyond the subject wells of this hearing. I believe that they may have fallen into other hands of ownership or operatorship. I do know that the division considered that, but that these 3 wells at this time are just the only ones subject to this agency action.
Are those the only well? This goes to the question, if you use the $120,000 for these 3 wells, does Tiger need to have bonding for the wells it has left? I want to be sure you don't, call the bond for 3 wells when there are 3 or 4 more that work needs to be done and there's no bond.
So can I jump in? And I wonder if maybe there's division staff online that can correct me if I'm wrong, but Ms. Garrison, it's my understanding that the remainder of Tiger's wells that are within state jurisdiction have been appropriately plugged and abandoned and reclaimed. It's just these 3 that are remaining, and it's just the one that requires plugging. The other 2 have already been plugged. It's just the surface reclamation. So they've been working through the process. They just kind of quit. And so these are the 3 that we're left with right now.
This will clear up everything for Tiger in terms of bonding obligations.
I can't be certain that they don't have any federal wells under federal jurisdiction, but in terms of the state wells, yes, it will.
Okay, thank you.
Mr. Borden.
Once again, I would just ask, does the division feel the $120,000 is sufficient to do all the abandonment and reclamation activities for these 3 wells?
I was able to ask the division this prior to this hearing, and the bond is for $120,000, and for all 3 wells, it's estimated to be $125,000 to $150,000. So it's close, but not quite enough. And that's just an estimate; it's not exact.
Thank you.
Thank you, Mr. Borden. Any other questions from board members or discussion?
Mr. Chairman?
Yes, Mr. Brown.
Not really a question, but a request. We always have this question, does the bond cover the reclamation costs? It would be nice if the division would just anticipate that question going forward and answer for us if there will be a deficit between the anticipated costs and the bond being forfeited.
We absolutely will be more aware of that. And to be 100% honest, it's funny because I told Charles you need to find out how much extra it's going to be because the board's going to ask you. And then I didn't do that for my matter a little bit ago, and I got that same question. So I do know that this is a question you guys have. We will be committed to making sure that we provide it in our initial presentation in the future. Thank you for the feedback.
Thanks, Haley.
Thank you, Mr. Brown. Ms. Souza? Well, I would believe that if there's no further conversation or questions, that at this time it would be appropriate to have a motion on supporting the division's request for this agency action. Is there anybody who would like to make said motion?
I move that we support the division's request in support of the agency action to use the amount forfeited to plug and reclaim the wells.
Thank you, Ms. Davis. Is there a second?
Maybe that's too lengthy. Let's just say I move that we support the division request.
Okay.
Second.
It's been seconded by Mr. Borden and Ms. Garrison. Any discussion on the motion? Seeing and hearing none, Ms. Carter, could you call the vote? I think you're on mute.
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. Levon Garrison, how do you vote?
Yes.
Mr. Chris Hansen, Chair Pro Tem, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you, Ms. Carter. The motion is carried. I assume that the division will prepare the appropriate documents, whether it be Mr. Lyons or Ms. Souza.
I'm sure one of us can do that for you.
Yep. And thank you for your presentation.
Thank you.
Well done, Mr. Lyons.
Thank you.
We could have been a lot harder, but we're all in this together. The next docketed item is docket number 2017-013-C, cause number RONG-2017-01-C, in the matter of ownership, designation, and or related matters. It's my understanding that we're at the position, unless there is some other discussion, that we're at the position of moving to adopt these rules as submitted to the Office of Administrative Rules and to be effective on the date of July 23rd, 2020. But division, is there a presentation or discussion on this matter you would like to have?
Mr. Hanson, this is Director Baza. I don't know if Haley wants to lead in with this, but say anything you need to, Haley.
I was going to jump in and say that Director Baza had was going to deliver the contents of the memo. So you go right ahead.
All right. Is that
Please
all right?
proceed.
Okay. Hopefully you can all hear me well. The operatorship rules, as you recall, were presented to the board for recommending formal rulemaking commence back at the May hearing. So in June, those operatorship rules were published in the state bulletin, and the comment period ran for 30 days. So I'm going to try to present my screen and draw your attention to a memo that Natasha prepared for the division. I think I've got the wrong one up there. Hold on. Let me try that again. So are you seeing Natasha's memo?
Yes.
Okay. So, yeah, Natasha prepared this earlier this week, and it's just a quick summary of where we're at. I'm going to do my best to explain the memo, but I told Natasha if you ask any tough questions, she might have to jump in and bail me out here. But again, we published it in the state bulletin, comment period of 30 days. That ended on July 15th at 5 p.m. We analyzed the comments that were submitted. One public comment was received from the Utah Petroleum Association, and that is part of your board packet at this point. It's been filed with Julianne and submitted as a comment on this docket. The division has read that and analyzed it. The comment reminded the board of a conversation surrounding the shortening of the 10-day application for permit to drill appeal period and the importance of having that provision in place. But the comment did not suggest changes be made to the public rule. And in fact, the Utah Petroleum Association supports the rule as published. So the bottom line is that the division is advising the board to adopt the operatorship rule. The division is recommending an effective date of July 23rd, and that will comply with the Utah code that there be a certain number of calendar days between the period of time the rule closes and the effective date. So with that, I will be open for any questions, or Ms. Sosa, maybe you can add anything you want to add at this point.
The only comments that I had planned to add were just to lay out the Utah code requirements with the 7-day waiting period. And so Director Baza covered that in his presentation. So I don't have anything additional to add.
Okay, thank you. Mr. Baza, do you have any other comments you'd like to make?
No, we recommend going forward with the operatorship rule as published. It's been a long drawn out process, and we certainly appreciate the board's support, especially during the initial stakeholder engagement on this. And this follows on the heels of the compulsory pooling rule, which was adopted earlier this year. And at some point, we'll address the third part of that set of rules. But I think that will probably be postponed at this point till a future date.
Okay. Again, I second your appreciation of everyone who's worked on these, the division, the members of the public, the board. And at this time, I think it would be appropriate to have a motion to adopt the rules as submitted to the Office of Administrative Rules and an effective date of July 23, 2020. Is there a motion to that effect? Somebody on the board would like to make?
So moved, Mr. Chairman.
Second? Is there a second?
Second.
Thank you. Any discussion on this motion? Seeing and hearing none, it's appropriate to have Ms. Carter call the vote of the board members. If you would, please proceed.
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chris Hansen, Chairman Pro Tem, how do you vote?
Yes.
Mr. Chair, I have 7 affirmative votes.
Thank you. The motion is carried. I don't know that there's anything else that we need to do as a board on this matter other than adopt it. Yeah. Before we close the hearing or entertain a motion to close the hearing, the board needs to have a discussion offline in deliberation on some litigation matters. So I'd like to entertain a motion to end the hearing, but the board members, please, after the hearing is closed, go on to our deliberation website. So,
Mr. Hanson?
yes,
Hanson,
Mr.
this is
Baza.
Director Baza. I gather from that you would prefer to postpone the final briefing matter until next month.
Yes, I'm sorry. It took me a moment to remember. You know, if you'd like to go ahead and complete that briefing matter, we could now, or wait until next month.
It's at the board's pleasure. We're ready to do that, but it'll take about, I'm going to guess, between 15 and 20 minutes from start to finish.
There are some folks, I'm sorry, on the board that probably need to run. We may lose some of the members. Would you be offended if we waited until next month to
Not at all.
hear that presentation?
We'll go ahead and plan for that next month then.
I apologize again for our lengthy discussion this morning that caused this delay, but we will hear that presentation in August. And again, thank you for being patient with us.
Thank you so much.
I would entertain a motion to adjourn.
So moved.
Any second on that motion?
Second.
Okay, we don't need one. All those say aye.
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 We are adjourned. And board members, let's please hop on to our deliberations website. Thank you.